and gentlemen, Ali, hello, good day from Australia, and welcome to the Asian Development Bank's International Commercial Arbitration Workshop for the legal community of Palau. And this is brought to you in conjunction with the Palau Bar Association. We thank both organisations for having made this event possible and having brought together this many people from who are spread at this time over many corners of the world. We have a session which will last for 1.5 hours, and really the purpose of today is to cover ground in relation to what is effectively the world's newest International Arbitration Act, your International Arbitration Act, which commenced in March 2021 after you acceded to the New York Convention 1 year earlier. It's been an honour from my point of view to have been able to participate with the Attorney General, with the Minister of Finance, with the Office of the President, and of course with Gary Bourne, who you will be hearing from as our keynote speaker, and with Christina Pack, to have been able to assist in the passage of the bill, which is now an act, and to present to you today, both as moderator and as speaker a little later. I have met with many of you. I've seen who's online today, and I have had the pleasure of coming twice to Palau. We sincerely wish we were with you today to be able to do this live, but at least we can do this over Zoom. So today we're going to cover a number of topics. We have, of course, Gary Bourne as our keynote speaker, as I mentioned. Gary is the chair of the International Arbitration Practice Group at Wilmer, Pickering, Hale and Dorr. He is the president of the Singapore International Arbitration Centre, and he is also a fellow ADB International Arbitration expert. We'll also be hearing today from Brenda Horrigan, who is the former president of the Australian Centre for International Commercial Arbitration and an independent arbitrator. We'll be hearing from Jo Delaney, who's a partner in Baker and McKenzie, and finally from Johnny Lim, who is counsel at Wilmer, Cutler, Pickering as well, with Gary Bourne. The topics I'll introduce each in more detail as they come to cover the topics. But of course, it's my great pleasure now to turn over to Gary Bourne, who, as I mentioned, assisted very intimately in this process. He addressed, we both addressed your Houses of Parliament, which had many excellent questions in relation to the passage of this Act. And without further ado, I now pass over to Gary Bourne for his keynote address. Gary.
It's a great pleasure. It's a great honor to have this opportunity to be with you, if only virtually, in this international arbitration workshop in Palau. We've made great progress over the last months in terms of legislative developments and introducing international arbitration, international commercial arbitration to both Palau and the South Pacific more generally. This workshop is an opportunity to put that legislative framework into practice, to begin putting it into practice. One of the reasons for the legislative developments, not just in Palau, not just in the South Pacific region, but worldwide, has been because of what I call the 5 and today 6 E's of international arbitration. Those 6 E's are the various advantages, the various benefits that international commercial arbitration, also investment arbitration, provides as compared to the alternatives. The 6 E's in summary, and then I'll say a few words about each, are: international arbitration is more efficient and more expeditious than the alternatives. It's also more expert and more even-handed. In addition, because of the legislative framework that I've mentioned and that you're familiar with, International arbitration is more enforceable than national court proceedings. Those were the traditional 5 E's of international arbitration. The 6th E these days is that international arbitration is more electronic. And let me say a few words about each one of those advantages of international arbitration, advantages that you can explore in the coming workshop. International arbitration is more expeditious than the alternatives because, unlike national court proceedings, which may have lengthy backlogs or logistical difficulties, particularly in this pandemic age, international arbitration is designed to be speedy and effective. Many arbitral institutions have fast-track arbitral procedures that allow smaller value disputes to be resolved quickly within 6 months or less. International arbitration also doesn't have the multiple layers of appellate review that can send parties just back to where they started after 6 years, not 6 months. For all those reasons, businesses around the world have concluded that international arbitration is more expeditious than the alternatives. As a consequence, because we as lawyers all know that time is money, international arbitration is also more efficient. It costs less at the end of the day, particularly when you take into account the possibilities of parallel or multiplicitous judicial proceedings in the courts of different countries. International arbitration is also more expert than national court litigation. National court judges are faced with significant challenges when they're required to litigate, to be a judge in every conceivable type of dispute, whether it's criminal law, administrative law, environmental law, landlord-tenant law, commercial disputes, traffic violations, and the like. In contrast, in international arbitration, the parties select the arbitrators. They have the freedom, the autonomy to choose the arbitral tribunal themselves, and after a dispute has arisen. As a consequence, what parties do, unsurprisingly, is choose arbitrators who are specialized in the subject matter of their dispute. If they have an insurance dispute, they choose insurance practitioners. If they have a shipping dispute of the sort that you might have in Palau, they choose maritime experts. A joint venture dispute, they choose someone with experience in both joint ventures and also the relevant subject matter of their dispute. And for all those reasons, international arbitration provides enhanced commercial and legal expertise as compared to the alternatives. International arbitration is also more even-handed. In addition to being more expert, it is more even-handed. International arbitration doesn't occur on either party's home turf. Instead, it occurs under the auspices of an independent arbitral institution, typically in an arbitral seat that is neither party's home court, neither party's home jurisdiction. In contrast, in international commercial disputes in national courts, very frequently the litigations take place on either one of the party's home courts or home jurisdictions, or in some cases on both their own home turf, with ultimately 2 sets of proceedings going forward, 2 sets of judgments being rendered. That brings us to the 5th E. International arbitration is more enforceable than national court litigations. That's true in particular because, as we now know, in Palau of the New York Convention, which in Article 2 makes international arbitration agreements more enforceable than forum selection clauses. Articles 3, 4, and 5 of the Convention also make international arbitral awards more enforceable than national court judgments. When parties agree to arbitrate as a means of resolving their commercial disputes, they can do so with confidence that both their international arbitration agreement and the outcome of that agreement, the arbitral award, will be subject to recognition in nearly 170 countries all around the world. There's no equivalent for choice of court agreements or for national court decisions. Arbitration enjoys an enforceability premium that is also attractive for businesses. And finally, in this pandemic era, international arbitration is more electronic than national court litigations. International arbitrations have gone forward with virtual hearings, a little bit like this virtual workshop, notwithstanding COVID-19. And that, in turn, enhances the efficiency and expedition of the process, the first two E's that we began with. In this workshop, you'll begin to learn how, you'll study harder how the 6 E's of international arbitration can be put to practical use in Palau and elsewhere, how businesses can resolve their commercial disputes more efficiently, more effectively, which is at the end of the day the reason that the New York Convention was ratified, the UNCITRAL model law was adopted. Good luck in the coming days. It's a noble enterprise that you're embarked on, and I wish you the very best of luck. Thank you.
Thank you. Thank you very much, Gary, for those remarks and particularly the insight into what's happening since COVID has struck and the adaptation that arbitration has been able to undertake during this period. I want to now introduce to you our next speaker. Our next speaker is Jo Delaney. Jo has very significant experience in international arbitration over the last 20 years. She's currently a partner at Baker and McKenzie, but she's also a member of the International Court of Arbitration, the very prestigious Paris-based arbitral institution, and she's an Australian alternate member to that. She's a counsellor on the Chartered Institute of Arbitrators, and I say has had a very long career in this particular work. She'll also be assisting the Asian Development Bank in coming years and has assisted over the last few years in part of this reform and some of the training as well. So I turn over now to Jo Delaney.
Thanks, Daniel, and thank you to the ADB for inviting me to be part of this workshop. I appreciate that it is a little bit difficult in a virtual environment to ask questions, but we are all can be seen on the Zoom platform. So if you do have a question as we go through, please raise your hand. You could raise your hand electronically, or you could just unmute yourselves and interrupt me, or you could put a question in the chat box. It would be great to make this workshop interactive so that we can maximize the extent to which you're able to learn more about international arbitration. We're here to help you with putting in force your Arbitration Act and very much would like to help you with that process. So the two topics that I'm going to start with is firstly to look at the different types of arbitration, which we often divide into two categories: ad hoc arbitration and institutional arbitration. And then I'll talk a little bit about drafting an arbitration clause and the key elements for an arbitration clause. So firstly, looking at ad hoc versus institutional arbitration. So Daniel mentioned one of the global institutions, the ICC. The ICC is one of the oldest arbitration institutions in the world. The LCIA is also a very old institution that is based in London. In Asia, we have a number of institutions, such as the Singapore International Arbitration Centre in Singapore, the Hong Kong International Arbitration Centre, and in Australia, we have the Australian Centre for International Commercial Arbitration. These institutions help parties to administer the arbitral process. So it's very similar to a court registry that you will see in the normal court system that you're involved with. And just like when you go to court, you turn up to the registry and you file your summons or your writ or statement of claim, whatever the process is to start the court proceedings, you would do the same with commencing an arbitration. So you would send your notice of arbitration or your request for arbitration to the institution. Now, there are a number of benefits with these institutions. So I'll first just run through some of the benefits of an institutional arbitration, And then I'll talk a little bit about an ad hoc arbitration and how it's different. So as I've mentioned, the institutions help to administer the process. Each of the institutions have their own arbitral rules. And the arbitral rules are similar to court rules, as you would see in your court system. They set out many of the steps that are required for the arbitral process. And they support and supplement the steps that are set out, or the different processes that are set out in the arbitration legislation. So what's set out in the UNCITRAL model law and what is now set out in the Palau Arbitration Act. So the first example to mention is, as I said, the notice of arbitration. If you are going to commence a SIAC arbitration in Singapore, then you would look at the SIAC arbitration rules. You would look for the process for commencement of an arbitration, and that refers you to the notice of arbitration. And in the rules, it sets out what you need to include in the notice of arbitration. So, for example, the names of the parties, you need to refer to the arbitration clause, a brief description of the dispute, and the relief sought. So that's very helpful when you're commencing an arbitration. More importantly, the Secretariat will then help you with getting the process up and running. So unlike the court system where you've got available judges ready to sit in a case and the case is allocated to one of the judges, in an arbitration, you need to appoint your arbitrators. Now, of course, this is also one of the benefits of arbitration. As Gary Bourne said, you can appoint an arbitrator with the relevant expertise for your particular dispute. Now, it may be in your particular case, you're appointing one arbitrator, or it may be that you are appointing 3 arbitrators. The institution can help with that process. The rules will set out a process itself, which will typically set out how the parties are to try and agree on the arbitral tribunal. If there's one arbitrator, they'll try and agree on the sole arbitrator. If there's 3, each side will appoint an arbitrator, and those 2 will appoint the chair or president of the tribunal. Now, if a problem occurs during that process, for example, the respondent does not participate in discussions for a sole arbitrator or fails to appoint their arbitrator, then the institution has a process that you can rely on and then use to get the tribunal appointed. And the institution will appoint any missing arbitrators, or any arbitrators that have not been appointed by a party, or if the parties can't agree on an arbitrator, or if the 2 party-appointed arbitrators cannot agree on a chair. The institution will step in and will then appoint those arbitrators. So this is very helpful. This institution will also give you a case management team, and the case management team will help you through the arbitration process. So they will communicate with you during the process. They will keep track of where the arbitration is going. There will be a procedural timetable set out by the arbitrators, by the tribunal, but the case management team will also help with that process. They will keep an eye on deadlines being met. They will have a record of communications with the tribunal, and then they can help the parties just on the administrative side. One of the very important things that they help the parties with is the costs of the process. So they help with arranging the costs or the payment of the arbitrators. Unlike court, where the judges come for free, the arbitrators unfortunately need to be paid, and the process needs to be paid for by the parties. And that payment process can be administered by the institution. Again, this is particularly helpful if the respondent is not participating in the process. So it may be that the respondent refuses to pay its share of the cost. The costs are typically shared by the parties. And it may be that the respondent refuses to pay for some reason. The institution can then communicate with the respondent and request them to pay and give them deadlines to pay by. Unfortunately, many institutions then ultimately provide that if the claim is to proceed, the claimant needs to pay the share of the respondent's costs. But this is noted and recorded by the institution, and the claimant can seek payment of those additional costs later on from the tribunal. So if, for example, the claimant wins in the case, it can seek payment of all of the arbitration costs, including the respondent's share, from the tribunal, and the tribunal can order the respondent to pay all of those costs. But it's really that administrative process that the institution helps with. The institution can also help with scrutinising an award. So once the tribunal prepares a draft award, some of the institutions, like the ICC and to some extent SIAC in Singapore, will review a draft of the award. The Secretariat will review it, and experienced arbitrators involved with the Court of Arbitration will also review the award just to make sure that there's nothing obvious that might lead a party to challenge the award on procedural grounds. The idea of this process is to ensure that the award is enforceable and that there's nothing obvious that the tribunal has missed, or to pick up, for example, typos, particularly typos in monetary amounts can be very important for the ultimate damages award or the ultimate order of the tribunal. It's the order that you will be seeking to enforce in court if you want to go through an enforcement process under the New York Convention. So that's a very important advantage of an institutional arbitration. Just to mention a little bit more about the rules of institutional arbitrations. One benefit with these institutions is that the rules are typically kept up to date. They are revised regularly by arbitration lawyers involved in the process and involved with that institution, and also by the Secretariat. And this ensures that the rules are capturing any developments or addressing any issues that have been occurring in the past few years. So over the last 10 to 20 years that I've been practicing arbitration, with these updates and revisions, we've seen the introduction of emergency arbitrators who can be appointed to issue injunctions or intra-measure orders on an urgent basis. And we've also seen the emergence of more emphasis on expedited arbitrations, which can be particularly important for either arbitrations of a smaller value, so that you get a more cost-efficient process and a process that focuses on the real issues in dispute. But expedited arbitrations can also be used when there is an issue that needs to be addressed very quickly. So this is yet another benefit of an institutional arbitration. Now, in contrast, you have ad hoc arbitrations, and we still often see this in arbitration clauses. Typically, if an arbitration lawyer looks at the draft arbitration clause, they will advise against a party having an ad hoc arbitration, which solely relies on national arbitration legislation. So you could, for example, have a clause that says arbitration will be conducted in accordance with the Palau Arbitration Act. Now, whilst the Act does set out a lot of relevant procedures and relevant steps and will provide support for the arbitral process, there are many other aspects or procedural steps that are set out in arbitration rules that could assist the parties. So this puts more burden on the tribunal to ensure that those different aspects are covered in its procedural orders and in the procedural timetable. One classic example of this can mean that if it comes to the appointment of arbitrators, the parties are forced to go to the courts for the appointment of an arbitrator in the event that a party doesn't appoint an arbitrator or if there is no agreement. Some arbitration legislation provides that all arbitral appointments are to go to the court, and then the court will decide who to appoint as an arbitrator. Now, this can be fine if the court is efficient and addresses the issue quickly. But in the past, we have seen in some jurisdictions, it can take the court some time to deal with just this issue. It could take 6 months, 9 months, perhaps a year. And this means that you can't get your arbitration process up and running. Now, some arbitration legislation, like the Australian legislation, provides that the appointing authority is not the court, but is an arbitral institution. So it appoints a KICA to be the appointing authority in that circumstance. Another form of ad hoc arbitration is where the parties have referred to the UNCITRAL rules. So the UNCITRAL rules go with the model law. They are absolutely fine to use, and it is a good alternative if the parties cannot agree on an institutional arbitration or institutional rules. But having said that, it does mean there is no institution behind it who can assist with case management and can assist with appointing the tribunal. The UNCITRAL rules provide for the parties to agree on an appointing authority to appoint arbitrators, or for the Permanent Court of Arbitration to appoint that appointing authority. Now, the Permanent Court of Arbitration in The Hague, one of the oldest arbitral institutions, will administer some UNCITRAL arbitrations, and some of the other institutions will also do so. But it is a little bit more difficult. There is more burden on the parties and more burden on the tribunal. For example, the parties will need to discuss with the tribunal the costs and putting down a payment or advance payments for the costs of the tribunal. So I'll just pause there before I move on to drafting an arbitration clause, just to see if there are any questions. Okay. Well, please feel free to ask questions as we go along. Now, looking at drafting a clause, there are different views as to the key elements of a clause. For the purpose of today's workshop, I'm going to say there are 6 key elements of drafting an arbitration clause, and that includes the governing law of the contract, and I'll get to that one last. Now, the first key element is the submission of the dispute to arbitration. This is absolutely essential because this is where the parties' agreement to go to arbitration arises. So one of the fundamental bases or principles of arbitration is that it's based on the parties' consent, and the parties must agree to go to arbitration with each other. That submission to arbitration, that agreement to arbitration, is set out in the arbitration clause, and typically is the part of the clause that deals with this is where it says the parties agree to refer all disputes to arbitration. Now, when it says all disputes to arbitration, the scope of disputes to be referred to should be very broad. Some jurisdictions will attach a broad meaning to the definition of scope of disputes or the definition to all disputes or any dispute. But some jurisdictions will focus on the specific language being used by the parties and will consider whether the parties meant to refer the particular dispute to arbitration or whether that particular dispute was to be referred to court or another forum such as expert determination. So typically when we're drafting clauses, we draft them very broadly and we add in language to make sure it gives a clear indication that all disputes are to be referred and that the definition of disputes is as broad as possible. So typically we would say any dispute or all disputes arising out of, relating to, or in connection with this agreement are to be referred to arbitration. The courts in the past have drawn distinctions between arising out of, relating to, in connection with. So that's one of the reasons why we would prefer to use all of those phrases. So the submission to arbitration and the definition of disputes is very important. I would also recommend against trying to split different types of disputes between arbitration, court, or another forum like expert determination. One of the examples that we are increasingly seeing is in construction matters, for example, technical disputes are being referred to expert determination, which might be appropriate in certain cases. And then non-technical disputes or commercial disputes are being referred to arbitration or to court. Of course, the first question that comes up with that type of distinction is, what is a technical dispute, and is the dispute we're dealing with a technical dispute that should be referred to expert determination or to arbitration? It would be simpler for the parties if the specific clauses of the contract that relate to technical disputes, where a dispute might arise, that those clauses are referred to as to what might be referred to expert determination, rather than a broad definition of technical disputes. Now, just before I move on to some of the other elements, I did have a question about what arbitral institution would be used in Palau rather than ad hoc arbitration. And this is relevant for the next 2 points, actually, and when it comes to drafting an arbitration clause. The first thing to emphasize is that what we're talking today about is international arbitration that relates to Palau. So typically when you have an international arbitration relating to a certain country, because, for example, it relates to a project in that country or a transaction in that country, the parties will refer disputes to a country, an institution that is outside of that country, so outside of Palau. So in the Asia-Pacific region, for an Australian-related dispute, we will often see disputes referred to arbitration in Singapore or in Hong Kong, because Singapore is seen as a neutral place to resolve those disputes, as is Hong Kong. And it's one reason. Number two, it's an arbitration hub. It's well known for its arbitral institution is well known, well regarded, and the courts are arbitration friendly and very used to dealing with arbitration issues, which is important, as I'll explain in a moment. And the SIAC rules, as the Hong Kong rules, the HKIAC rules, are modern, up to date, and deal with many of the issues that arise. So an Australian project will typically refer an arbitration to arbitration in Singapore under the SIAC rules, or arbitration in Hong Kong under the HKIAC rules. And this would be the same for Palau. And so I would suggest that you would then recommend arbitration in Singapore or Hong Kong, but also you have the options of Australia or New Zealand, or possibly another jurisdiction in the Asia-Pacific region. And I would suggest that then it's better to refer to one of the institutions operating there in Australia, New Zealand, Singapore, or Hong Kong, rather than referring to ad hoc arbitration, particularly with the seat in Palau, because then the courts will have to deal, for example, with the appointment process for the tribunal, and will have to deal with some additional issues that might come up through the process. So please, if that doesn't answer your question, please raise it again as we go through today. Okay, so the follow-up question is that the international contracts arbitration must occur in a neutral country. It's not that they must, it's not an absolute mandatory requirement. It's more what's acceptable between the parties during the negotiations. So usually it's more acceptable to the parties that they agree to a neutral forum, because then both parties feel that they'll get a fair hearing. Arbitration is regarded usually as neutral in any event, but it does mean that it's going to be heard in a neutral venue, and also that the courts of the venue you're choosing are usually arbitration friendly and used to dealing with these issues. So, for example, I would recommend going to arbitration in Singapore or Hong Kong over some of the other jurisdictions in Asia, because the courts have less experience of dealing with arbitration issues than the courts in Singapore and Hong Kong. And that's important for my second element, which is the seat of the arbitration. So the seat of the arbitration is very important for a number of reasons. Now, the clause will usually say all disputes are to be referred to arbitration. The seat or place of the arbitration is Singapore or Hong Kong. You could say the venue of the arbitration, or you could say arbitration in Singapore or Hong Kong. But those phrases don't have an accepted meaning amongst the arbitration community and amongst tribunals or amongst the courts. Whereas a reference to the seat or the place of arbitration has an accepted meaning in the arbitration context. And it means that the seat or the place of arbitration is relevant for determining the procedural law. So if the seat or place is Singapore, Singapore law will typically apply as the procedural law to the arbitration. So when it comes to dealing with procedural questions, Singapore law will apply. It also means that Singapore courts will supervise and support the arbitral process, which is why it's particularly important for the reasons I was mentioning on institutional versus ad hoc arbitration. And it's important that the Singapore courts have dealt with many of the issues that have come up in an arbitration, such as, can the parties consolidate the arbitration? Is this particular dispute to be referred to arbitration or to be referred to the courts? Is the limitation of period applicable to this particular arbitration? There are many different issues that could come up, and then those courts will assist with that, with many of those issues. Another example would be if the Singapore courts assist with collecting evidence and with issuing, in some cases, subpoenas to help the parties to collect evidence in support of the arbitral process. And finally, the seat is important because it gives nationality to the arbitral award for the purpose of the New York Convention. So when you come to enforcing under the New York Convention, the first question is, where was the award made? What was the seat of the arbitration and where was the award made? So if it's a Singapore-seated arbitration, the award was made in Singapore for the purpose of the New York Convention, and then it can be enforced in any other country that is party to the New York Convention. So that's particularly important. Now, moving on to some of the other elements. So I'm only up to number 3, but the other ones are a lot shorter. So the clause should refer to the arbitral rules. And as I've mentioned, the importance of the arbitral rules is to help the parties through the process. The arbitral rules should typically go with the seat. So if you're in Singapore, go with the SIAC rules. If you're in Hong Kong, go with the HKISC rules. There are a few rules that can apply globally, like the ICC rules or the UNCITRAL rules. So the ICC rules are not typically connected with any place of arbitration. They can be conducted in or used for any place, whether that's Singapore, Hong Kong, Australia, Kuala Lumpur, or anywhere else in the world. And I've already mentioned the importance of the rules, so I won't go into that in much more detail. The fourth element is to mention how many arbitrators you want to hear your dispute. Do you want 1 arbitrator or 3 arbitrators? And this will depend on a number of factors, such as the amount in dispute. So bear in mind, you need to pay the arbitrators, the complexity of the issues that might arise, and ultimately how long you think it might take to resolve the dispute. If you think it's an issue that you need to be resolved quickly, then it might be appropriate to appoint a sole arbitrator. If it's more complex, then you might want 3 arbitrators so you get 3 different views, or 3 views that hopefully are consistent. So think about how many arbitrators you want to appoint. The 5th element is language, and this is important in some jurisdictions, particularly in some Chinese arbitrations, because it may be that in some Chinese arbitrations, the language would be Chinese or Mandarin, unless the parties have indicated otherwise. So typically you would include English as your language of arbitration, but in some jurisdictions you might include something else like French. And then the 6th element, as I mentioned, is the governing law. Don't forget to include a governing law clause. This law is to apply to the substance of the contract, the merits, how the contract is to be interpreted. And so it's important to include this either in the arbitration clause or elsewhere in the contract. Now, typically you'll see in a contract that the governing law goes with the jurisdiction clause, where the parties submit to the jurisdiction of specific courts. If you have an arbitration clause, you don't need the jurisdiction clause because you're going to arbitration instead of the courts. And you don't need the jurisdiction clause to be able to rely on the courts for the seat of the arbitration. So it's best just to delete the part of the clause that refers to jurisdiction. So those are the 6 key elements I would focus on. There are some other elements that are often included, like confidentiality. The parties might want to expressly state that the process is confidential, though this is increasingly unnecessary as it's in the rules or the arbitration legislation. We often see that the parties reserve the right to obtain interim measures or injunctions and to go to the courts to get the injunction. This also operates regardless of what's in the clause. Sometimes you'll see the clause saying that the arbitral award is final and binding. That also applies regardless of what's in the clause. It comes under the New York Convention and the arbitration legislation that applies. If you do have a multi-party or multi-contract project, you might then want to include joinder and consolidation clauses, and they're a little bit more difficult to draft. Otherwise, if you don't know where to start, I would encourage with going to the model clauses that the institutions have. So the ICC, SIAC, HKIC, AKICA all have a model clause that is a good place to start for using for your arbitration clause. I'm happy to help with any other questions as we go along.
Thank you very much for that, Jo. We appreciate that presentation. Very clearly set out what circumstances you might use ad hoc, what circumstances you might use institutional arbitration, and also some pointers on how to draft an institutional arbitration clause. During that session, I had a very good question from someone. I'll keep them anonymous, but they said to me, words to the effect, well, how effectively is this going to help our practice? Because many of our disputes are going to be smaller disputes. They're not necessarily going to be very large disputes where we want to go off to Singapore or have hearings in Australia necessarily. And while certainly appreciate that will be the case and that there may be occasionally some larger disputes, arbitration is very capable of dealing flexibly with smaller disputes as well. One such area, for example, is that all of the institutions that were referred to have expedited processes. So if you have a relatively small dispute, then these institutions have rules whereby this can all be done on the papers. It can all generally be done within 6 months. And so that's something to look out for if you feel you have a smaller dispute. The second point I want to make is how will this come up in your practice? Well, as Jo and Gary mentioned, there are 2 features of arbitration. First, it's a voluntary process. So it's only if it's a suitable situation between the two consenting parties to a contract. And second, where there's a foreign party to the proceedings. And Johnny will talk about this a little bit later, but the important point there is that you actually don't have an option to enforce on an award if you have, for example, a foreign company that comes in and does work in Palau but has no assets in Palau, does a terrible job, and you have to then sue them. You really, unless you're going to go to that other country and try and litigate in the other country, then you have very little option as to what you can do. But if you engage in arbitration from the outset, if you have an arbitration clause from the outset, then you have the option and the possibility of being able to get an enforceable award and effectively chase them in over 160 jurisdictions around the world if you need to execute on that and they don't pay up if you're successful. So really the point that I want to make is that, yes, it can affect your practice because whenever you have a foreign party, a foreign contract, then please think about arbitration as something that can be useful. And 2, it's not always going to be just the huge disputes. We're very mindful of that. Arbitration can deal through expedited arbitration, papers-only arbitration very quickly in this institutional fashion. I'll make one other comment about drafting the clause. Where are you going to start? And you asked Jo, and Jo gave you an answer about which institution you should look for. All of the institutions that we've discussed today have a suggested clause in their rule book. And the rule book is very short. Generally, you're looking about 30, 35 rules for these various institutions. And right up the front, often on their websites, they'll have a suggested arbitration clause which would incorporate their particular institution into that. And again, to recap, you can't really go wrong with Australia, New Zealand, Hong Kong, or Singapore as places to institutions to have as your arbitral institutes. All you would need to do is type in arbitration Singapore, and the first thing you'll come up with is SIAC, or similarly with Australia, and you'll be able to find those clauses and the rules very, very quickly and very, very easily. And just for the bigger picture as to why the Asian Development Bank has been interested and has been doing this reform in the region, the sole driver of this, or one of the key drivers of this, I should say, is really to attempt to increase foreign direct investment around the South Pacific. That is, foreign investors can look to the South Pacific and say, well, if we have a project here, can we contract with them? Can we, if things go wrong, do we have to litigate in their courts, or do they have to come to our courts? And this provides a neutral third-party way of resolving disputes. So hopefully you'll see that there is something in this which would assist you. Now, I actually realised at the outset I didn't introduce myself, although I have been to Palau twice, and I've done some seminars there and assisted Gary as well in addressing your Parliament. My name is Daniel Meltz, and I'm a barrister based in Sydney. I also sit as arbitrator, and I've, for the last 4 years, been engaged by the Asian Development Bank to assist in this reform work as well. Now, I have a short, the short brief topic that I have is in relation to conducting an international arbitration. And because we have some further speakers, I'm going to keep my remarks on this very short. Essentially, one of the differences between arbitration and litigation is that arbitration hearings are far, far shorter than you would otherwise expect in litigation that you would conduct. The reason for that is that arbitration depends a lot more heavily on written work. So before you would even get to a hearing, the parties would have exchanged much more detailed briefs than you would usually have done so in court. And similarly, after the hearing, the parties generally exchange post-hearing briefs as well, which are more substantial documents than would necessarily be in court. But the benefit of that is that for the hearings themselves, they're usually substantially shorter than you would expect. Arbitrators don't have days in their schedule usually to listen to cross-examination. It needs to be much more concise, and much can be covered in the written documentation, as I mentioned. Physically, how does it happen? You're used to going to court, you're used to having all that infrastructure around you. Well, if you've selected an institution, then all of these institutions have hearing rooms, so you can avail yourself of those. But let me give you another example. Let's say that you've chosen the Singapore International Arbitration Centre. You've chosen Singapore as the seat, but in fact, you don't want to conduct your hearings in Singapore because you don't want to go to the expense of that. You can agree with the other side to go to Fiji and conduct the hearings. You could, if the other side was amenable, you could conduct the hearings in Palau. That's not a problem, provided the other side is amenable to that, and you can agree to that if all the witnesses are there. But you generally, or very often, parties like to go to a neutral third country. If you do go to a neutral third country, then it's pretty simple. Parties generally get a conference room in a hotel. They set up a hearing room in one room, and each party has facilities in the other two rooms, and it generally proceeds like that. But having said that as well, of course, we're all mindful of what's been going on in the last year or two. And again, coming down to expenses and what arbitration's done and the flexibility that has happened is that much of arbitration is now conducted over Zoom. In fact, almost all of it has been conducted over Zoom over the last year or two. So again, that is something when you're concerned or worried about costs as to whether or not you can do it electronically. That's a great advantage that we have in the arbitration community to be able to do this. And that's worked pretty effectively. Witnesses have been cross-examined in different countries. They haven't had to fly out anywhere. Tribunals haven't had to fly out anywhere. And so that's generally worked pretty effectively. So when it comes to thinking about whether arbitration is an appropriate dispute resolution mechanism for your particular dispute, then again, I just go back to one, do you have any other option? That is to say, if you just have a judgment from a court in Palau, what can you do if your client has engaged a Korean company to build a resort in Palau and they have no assets there? There's really nothing that you'll be able to do with that judgment. So your only option there is going to be arbitration. And there are ways of making that more cost effective. As I say, for the smaller disputes, arbitration offers a very attractive alternative in this expedited dispute resolution that is offered by all the institutions for smaller disputes on the papers in 6 months. They assist with the appointment of the arbitrator if the parties can't agree, and it's a very, very efficient and effective process. So that's all I really want to say about hearings, unless I have any questions from anyone. I'll hand over now to introduce our next speaker. Our next speaker is Jonathan Lim. Jonathan is counsel at Wilmer, Cutler, Pickering, Hale and Dorr. He works in Gary Bourne's group, which is one of the most prestigious and leading groups for international arbitration anywhere in the world. And Johnny has assisted greatly around the South Pacific with this work as well in assisting with the drafting of acts and some training as well. So he has great experience in this area. Please welcome Johnny Lim.
Hello, everyone. Thank you, Daniel. I'll speak to you today about two things. They're both related topics, and I'm going to speak to you about your act, the new Palau International Arbitration Act, and the New York Convention that it seeks to implement. A few words about the New York Convention, and I like to spend most of my time talking you through the provisions of your new shiny International Arbitration Act, which is one of the most up-to-date and modern pieces of legislation to do with arbitration in the world. So the New York Convention, as many of you know, is one of the most successful international conventions in history, and it's widely credited with making international arbitration the most popular method of resolving transnational disputes. It has been ratified and acceded to by more than 160 states. Palau was the 163rd state to accede to the convention on the 31st of March 2020. By signing up to the New York Convention, states like Palau essentially take on two key obligations. Article 2 of the New York Convention requires contracting states to recognize and enforce international arbitration agreements, and Articles 3 to 5 of the Convention require states like Palau to enforce arbitral awards that fall within the Convention. And I'll talk a little bit more about how those provisions of the New York Convention then find their form in the UNCITRAL model law, which has been adopted in Palau and is now part of Palau's International Arbitration Act. There's no real substitute for using the provisions of the Act, so the Act's very new. But as it's started to be applied and used by courts, I think you will see that many of the concepts that Jo, Daniel, Professor Bourne have talked about are all very, really quite simple and straightforward. And there's no real magic to many of these topics that I will be talking about. Prior to the Act, I understand Palau did not have an arbitration law in place. So what the Act does is set out a framework for international arbitration in Palau that is supportive of international arbitration in that it requires the enforcement of international arbitration agreements and awards, like the New York Convention requires. It limits judicial interference in the arbitral process. It defines the scope of courts, actions in which courts can take to intervene in arbitrations. And in the main, it recognizes the autonomy of parties to shape the arbitral process, including, for example, appointing even-handed arbitrators. And it authorizes judicial support as necessary to ensure that the arbitral process functions smoothly. So if there are any deadlocks in the process, for example, courts can step in to make a decision, for example, on appointment of arbitrators if parties cannot agree. And so that's generally what the framework looks like. Of course, if you look at the Act, there are many more provisions than that, but they all are intended to achieve these four main aims. The Act is based on the model law, which is a comprehensive template published by the UNCITRAL for states to adopt as their international arbitration legislation. It was first published in 1985, and then revised in 2006. Since 2006, of course, there have been many developments in international arbitration, which have resulted in amendments to legislation in jurisdictions like Singapore, Hong Kong, Australia, which handle many arbitrations. And a lot of that reflects best practice and current modern thinking on arbitration. And all of that best practice and modern thinking is also incorporated in the new Palau Act. So let me just talk you through, in the time I have remaining, 7 key aspects of the Act you might want to pay attention to. The first is the scope of the Act. Perhaps the most important question: when does the Act apply? Section 5004 of the Act provides that it applies to international commercial arbitrations commenced on or after the effective date of the Act, under an arbitration agreement whenever made. So what does that mean? It applies to international arbitrations and it applies to international arbitrations that are commercial. It also applies to arbitrations commenced after the effective date of the Act, without caring when the arbitration agreement was entered into. So any arbitration proceedings that start now, even if the arbitration agreement was signed in 1999, for example, would be subject to the new Act. So the key questions then are to consider when an arbitration is international and when it is commercial. The first question is really quite easy to answer because Section 5004C adopts a very clear definition from the model law. Essentially, an arbitration is international if the arbitration has an element that subsists outside of Palau. For example, if parties have different places of business and arbitrate, that's by definition an international arbitration. If one of the places involved, if the place of arbitration is outside of the party's usual place of business, if parties are Palauan, but they decide to arbitrate in Sydney, that's an international arbitration. Or if the contract or the commercial relationship is to be performed in a country outside of the party's usual place of business. So if 2 Palau parties decide to enter into a contract for the sale of coal in Australia, for example, that's also an international arbitration. And lastly, the Act provides that if you agree it's an international arbitration, then it's an international arbitration. When is a dispute commercial? The Act itself doesn't define it, but if any doubt arises about it, actually the model law itself provides a pretty neat and broad definition. It's in footnote 2 to the model law, which is available on the internet. And it provides essentially a very wide interpretation that covers all kinds of disputes arising from relationships of a commercial nature, whether that comes out of the contract or otherwise. So you could look at the model law as well, if you're deciding whether a dispute falls within the Act. But essentially anything with an international element and which is commercial when arbitration starts after March 2021 is likely to be covered by the Act. The second point I'd like to make is it's a fundamental organizing principle of the model law is that the courts in the seat play a special role, but at the same time they play a special role in that they supervise and are responsible for taking certain steps in the arbitration proceedings if necessary. The flip side to this is that they exercise this responsibility judiciously in accordance with the provisions of the Act. The Act, at Section 5007, essentially adopts Article 5 of the Model Law, and it sets out the principle that no court shall intervene except where so provided in the Act. So in other words, the court is only empowered to intervene in the arbitration where there's express provision in the Act that enables it to do so. And that's why it's important that you familiarize yourself with the provisions of the Act, because they define the permissible scope of intervention by courts. And if you want a court to do something, it needs to be spelled out in the provision of the Act. The next thing I'll talk about is how Article 2 of the New York Convention, which I talked about earlier, one of the key aims of the New York Convention is to ensure that when parties agree to arbitrate, when they sign arbitration agreements, those are enforced. And how is that given teeth or the force of law in Palau? That's through Section 5102 of the Palau International Commercial Arbitration Act, which is itself based on Article 8 of the Model Law. And it provides essentially that where a court before which an action is brought in a matter that is the subject of an arbitration agreement shall refer the parties to arbitration, unless it finds that the agreement is null and void, inoperative, or incapable of being performed. You'll see from the word shall that this is a mandatory provision. So where Section 5102A applies, a court must stay in favor of the parties arbitrating. This is not just in Section 5102A. If you look at Section 5102D, it also provides that if the court refers the parties to arbitration, it shall make an order staying legal proceedings in that action. That means any litigation proceedings are suspended insofar as they are the subject of an arbitration agreement. This is virtually sort of uniform across jurisdictions that have implemented the New York Convention, all the 160 plus states, as well as countries that have adopted the model law. The question the courts will then have to consider is, what is an arbitration agreement? If you're looking at that question or that question's interesting to you, Section 5101A actually sets out a pretty comprehensive definition of an arbitration agreement. It's basically any agreement in which parties have intended to arbitrate, and it can arise out of any legal relationship. It's a very broad definition. You'll see from Section 5101B that an arbitration agreement has to be in writing. And that mirrors the requirement in the New York Convention, Article 2, that requires arbitration agreements to be writing so that they can be enforced. But if you look at Section 5105 of the Act, it actually provides for a very broad definition of arbitration agreement in writing. Essentially, it's in writing if it's recorded in any form. So even an oral contract that's referred to, for example, in an email or a letter, would be an arbitration agreement in writing. An arbitration agreement is even in writing if it's alleged in the statement of claim but not denied in the statement of defense. And the Act is also very clear that you can enter into an arbitration agreement through electronic communications, for example, by email. Obviously, there are more complicated questions to do with whether an agreement is valid, null and void, inoperative, incapable of being performed. That's something that Palau courts will have to consider, but they will have the benefit of many decisions in courts of other jurisdictions that have considered the exact same question under the model law. Courts in the US, courts in England, in Australia, Hong Kong, Singapore, even in jurisdictions that have not adopted the model law. Essentially, this is a uniform test that courts apply almost all over the world to decide whether to stay their proceedings in favor of arbitration. The fifth aspect of the Act that you may wish to pay attention to is provisions on the appointment of arbitrators. As Professor Gary Bourne said, this is one of the benefits of arbitration. And as Jo Delaney said, this is a key distinguishing feature with court proceedings where you have an assigned judge. In arbitration, you can play some part in choosing who decides the case. Sections 5201 and 5202 are based almost word for word on the model law. And essentially, they embody the key principle that parties are free to choose the number of arbitrators deciding their case, as well as the method for appointing those arbitrators. And in the event parties don't choose, you don't have to have provisions on this in your arbitration clause, because if you don't say anything at all, sections 5201 and 5202 also provide for default rules. These are rules that apply if parties don't say anything. And what's the default? The default is that you get 3 arbitrators. In the case of 3 arbitrators, each party will appoint 1 arbitrator, and the 2 arbitrators appointed by the parties will appoint the presiding arbitrator. These are all default rules, so parties can decide to modify them if they choose to in their arbitration agreement. But if they don't, these default rules in the Act are there to facilitate the appointment of the arbitrators. The Act also provides, I think, as Jo said earlier, for some means in which courts can assist in the constitution of the tribunal. And also it provides that there's a principal constraint in how parties are free to choose their appointed arbitrators, which is that arbitrators must be independent and impartial. It's a basic guarantee of a fair process, and parties cannot agree to have non-independent arbitrators. In the Act, it's really policed by a disclosure and challenge regime under Section 5203. So 5203A requires a potential arbitrator to disclose circumstances likely to give rise to justifiable doubts about his impartiality or independence. The words likely to give rise to suggest a very broad test for disclosure. So arbitrators are supposed to disclose anything that might be perceived to be impairing their independence or impartiality. As for challenges, Section 5203B provides that an arbitrator may be challenged if circumstances exist that give rise to justifiable doubts about their independence or impartiality. The word justifiable here suggests that it's an objective test that will be applied to determine whether an arbitrator is impartial and independent. There's a lot of case law on this, again, in many jurisdictions that Palau courts and Palau lawyers can consider. Courts have wrestled with these issues for many, many years. There's also party practice that has been crystallized in the IBA guidelines on conflicts of interest, and those you can consult as well if you're deciding a question to do with whether an arbitrator is independent or impartial. It's got a list of different kinds of scenarios in which potential conflicts of interest can apply, and it applies a traffic light system. There's a green list, there's an orange list, and there's a red list. And it lets you know, green list is completely okay, red list is completely not okay, and orange list is everything in the middle. Two or three other things I'll talk about very briefly in light of our time. I think if you look at the Act, Section 5512 sets out an express guarantee of the confidentiality of an arbitration. It's seen by some as a benefit of arbitrating a dispute rather than going to a court. You can have your dispute settled without the noise of public scrutiny, without having dirty linen aired over local or international media. There may also be commercial sensitivity, for example, if there are trade secrets involved or special IP issues. The Palau Act contains a pretty progressive provision on confidentiality. It's based largely on the Australian International Arbitration Act, as well as some arbitration rules, leading arbitration rules. Essentially, 5512A sets out a broad scope of confidentiality applying to all documents relating to the arbitration proceedings or to any awards rendered by the arbitrators. And then 5512B then sets out the carve-outs from that broad duty of confidentiality. These are exceptions that apply if a party is basically required by law to make a disclosure, ordered by a tribunal to make a disclosure, or has to make a disclosure to pursue a legal right or interest. Finally, the Act has provisions dealing with the setting aside of arbitral awards or the refusal of enforcement of arbitral awards. Setting aside is essentially the way a party dissatisfied with an arbitration award can challenge an award before the seat of arbitration. It's provided for in Section 5701 of the Act. And for international commercial arbitrations in Palau, Section 5701 is essentially the exclusive remedy available to parties who are dissatisfied with the arbitration award. You can see that from the text of 5701A itself. It says application may be made only under this provision. That means that unless the parties have otherwise agreed, there's no other action available to challenge an award. But note, obviously, if a party is dissatisfied with an award, it also has available the passive remedy of resisting enforcement of an award. Let's say an award is made by arbitrators in Palau, but there are assets in Hong Kong or Australia, where enforcement is sought in those jurisdictions. For example, a party can decide not to set aside an award in Palau, but resist only the enforcement of the proceedings in Hong Kong, for example. What is a setting aside? It's not a substantive appeal on the merits of an award. There are only limited grounds for setting aside. They're focused usually on the jurisdiction of the tribunal, compliance with basic rules of due process, whether the subject matter of the arbitration is capable of being settled by arbitration, and the public policy of the seat. This limited scope of recourse gives effect to what we discussed earlier, that policy of minimal judicial intervention and being supportive of the arbitral process, which enhances all the 6 E's of the arbitration process, and to give parties the benefit of the arbitration that they agreed to have. One thing to note is that setting aside applications have to be brought within 3 months. In section 5701C, it says this expressly. There's a question about whether courts have the power to extend time. Some courts applying the model law provision, because section 5701 is based on Article 34 of the model law, some courts have interpreted this to be a strict time limit. For example, Singapore courts say that any applications filed outside of 3 months, the court has no power to extend, because as we've seen earlier, the model law has this principle that a court has no power except where expressly provided in the Act. So if the Act doesn't provide a power to extend the time for making an application to set aside an award, then there's no power to do so. So that's the position of the Singapore courts. It may be an issue Palau courts have to decide. And related to setting aside, obviously, Chapter 58 of the Act has provisions relating to refusal of enforcement. I wouldn't say much here because the grounds for refusing enforcement are basically the same as those for setting aside, with some minor differences. And so the idea here again is that an award is presumptively valid unless successfully challenged. And the Act provides that it would be enforced and treated like a local court judgment unless one of these grounds, one of these exceptions, is established by a party dissatisfied with an award. And again, they are limited grounds, and they are the only grounds a party can raise. So that's my whirlwind tour of the new Palau International Commercial Arbitration Act. I'm happy to take any questions, of course, about how they will be used.
Okay, well, thank you very much, Johnny. I think we do have a couple of questions coming through, and we'll address those. Hopefully we'll have a little bit of time later. But that was a very helpful introduction to your new Act. Thank you, Johnny. Next, we have got Brenda Horrigan. Brenda is a US-trained attorney, you'll be happy to know, and she's the only panelist today who's actually visited Palau for leisure. She has recently left or is in the process of setting up in Singapore now as an independent arbitrator, but she was formerly the president of ACICA, which is the Australian Centre for International Commercial Arbitration. She held that role with some distinction for a few years, and she will be sorely missed, but we're very happy to have her to assist today with the topic of enforcing and resisting arbitral awards. Brenda.
Thanks, Daniel. Before I get to the topic of recognition and enforcement, I thought it would be useful, given some of the questions that were brought to Daniel earlier, to mention that the ACICA Practice and Procedures Board actually has some a very useful toolkit on the ACICA website that addresses some of the questions that were raised. So the differences between litigation and arbitration, the differences between memorials and pleadings, what an arbitration process looks like. And so to the extent that any of you are interested in further information, please do go to the ACICA website. It's ACICA, so acica.org.au. And then you can see the tab for the Practice and Procedures website. So turning to enforcement, as has been mentioned by several of the panelists, recognition and enforcement of international arbitration awards is under the New York Convention. I think as of last count, there are 168 signatories to the convention. The convention applies to the recognition and enforcement of arbitral awards made in the territory of a state other than the state where recognition and enforcement is sought. So that's what makes it international enforcement. It also applies to arbitral awards not considered domestic in the state where their recognition and enforcement is sought. So as Johnny was mentioning, the parties can agree to treat an arbitration as international. And if they've done that, then as long as the local law permits that, it would be considered international, even if the two parties would otherwise be domestic. And as was mentioned, the agreement must be in writing. Many jurisdictions in their domestic legislation have very expansive views of this, what the writing requirement entails. One thing to keep in mind, however, is that under the New York Convention, in order to obtain recognition and enforcement, the party applying for recognition and enforcement has to submit two things. One, the duly authenticated original award or a duly certified copy of the award. That's pretty easy because the tribunal members will have issued an award that they will have signed, and either they will issue multiple copies, you can request that, multiple originals, or you can get an original, a copy of an original certified. It is important, though, to make sure that you think ahead for recognition and enforcement. If you're going to be enforcing in a number of jurisdictions, make sure that you have sufficient certified copies available to submit, because you can't go back to the tribunal a year later and ask them to issue another one because they're functus by this point. The other thing which can create a challenge in some jurisdictions is that the New York Convention also requires the enforcing party to submit the original arbitration agreement or a duly certified copy thereof. Sometimes in some jurisdictions, this can be used as an excuse for refusing enforcement, because if the parties only have a photocopy of an award or of an arbitration agreement, they don't have the original, that can be problematic. Or if the original is an exchange of correspondence, some jurisdictions may find that problematic under the New York Convention. Most modern jurisdictions, most developed jurisdictions with modern arbitration laws such as Palau's, that's not a problem. But in some of the emerging market jurisdictions where there are very protectionist local courts looking for excuses to refuse enforcement, this can be an issue. It's not supposed to be, but it's one of the remnants. The New York Convention comes from the 1950s, and in 1950 you didn't have electronic exchanges. You didn't have all of these new methods of creating an in-writing, meeting the in-writing requirement. And so the language used in this provision of the New York Convention is a bit antiquated and can cause problems. So what actually is recognition and enforcement? Essentially, some jurisdictions will treat the two as a single term. Others will divide it into two processes. But what we're really talking about is recognition is the process of converting your arbitration award into a local court decision in the jurisdiction where you're seeking enforcement. So you're taking your award, and under the New York Convention, you're converting that to a local court decision. You're not relitigating anything. The court is simply taking the award and saying, yes, it meets the criteria. It now becomes a domestic decision that is enforceable here. And enforcement is the process of taking that award, which has been converted, and turning it into cash. So getting the bailiff or the mounted police or whoever actually enforces in that jurisdiction to go seize the asset and convert it to cash, or follow the process for converting that award into some monetary amount. Or other, if you have specific performance as your award, converting that into a local requirement that those actions that are the subject of the award be taken. So that's what we're talking about when we say recognition and enforcement. And the beauty of the New York Convention and recognition and enforcement under the New York Convention is that you can take your award to any jurisdiction that is signatory to the New York Convention. If you can find assets of the counterparty in that jurisdiction, you can enforce the award, recognize and enforce the award there. So you don't necessarily need to go to the home jurisdiction of the counterparty if you can find assets of the counterparty somewhere else. I had a situation where one of my clients had an award against a Central Asian party. The courts of that jurisdiction were notorious for finding excuses to not enforce awards, but there were assets held by the counterparty in another jurisdiction that we were able to go after in a much more friendly, arbitration-friendly jurisdiction in order to enforce the award. So that you have this flexibility, and you can enforce in multiple places. So if you can identify, a certain amount of assets in country A and additional assets in country B, you can enforce in both jurisdictions up to the total amount of the award. So obviously you can't get double recovery, but if you only have 50 million in country A and 25 million in country B, and your total award is for 100 million, you can enforce in both A and B without coming over your cap. The grounds for resisting enforcement are all set out in the New York Convention. They're very narrow. The first would be the parties to the agreement were under some incapacity, or the arbitration agreement is not valid. So if the person signing the arbitration agreement was a minor and didn't have the authority to sign, that would be a ground for resisting enforcement. Usually things like that will have been argued ad nauseum during the arbitration process itself, but they can be revisited on enforcement. In many jurisdictions, if you haven't raised a challenge to the validity of the arbitration agreement at the stage of the arbitration itself, you can't then credibly raise a challenge to the validity of the arbitration agreement at the recognition and enforcement stage, because the courts will, in most jurisdictions, will say, well, you should have raised that before the tribunal. If you have raised it before the tribunal, though, most jurisdictions will allow you to revisit that question. The second ground is the party against whom recognition and enforcement is sought was not given proper notice of the arbitration proceedings or was otherwise unable to present their case. There have been a few instances of awards set aside on grounds of lack of notice. Usually they were pretty egregious cases where there simply was no attempt made at notice. This unable to present their case is used increasingly by respondents who've lost as an attempt to say, well, my witness wasn't given long enough to be cross-examined. There were unreasonable denials for further document production. Usually those fail. They can take time. They can be expensive, but there have been some set-asides or refusals of enforcement on this basis where there was where it comes up most commonly is if the tribunal has decided on a theory that neither party has raised, and that neither party was given an opportunity to respond to. So if the tribunal just goes off completely on a tangent, that is usually a ground to at least raise an argument for setting aside, or for refusing enforcement. And as you'll notice, I keep referring to set aside and refusal of enforcement because in many jurisdictions, the grounds for those two actions are pretty nearly identical. It's not true in all jurisdictions, but in many they're very similar. And as Johnny was mentioning, that's true in Palau. The third ground is outside or beyond the scope of the arbitration agreement. This comes back to something that Jo mentioned. If the parties in their arbitration agreement have attempted to carve out a particular subset of the dispute and they want it to go to court or expert determination instead of to arbitration, then you can wind up with arguments on enforcement saying, well, actually, the topic of the award should have been carved out and sent to court or sent to expert determination. It wasn't part of the basket of dispute that was supposed to go to the tribunal. So that's why it's dangerous to have those kinds of carve-outs in an arbitration clause, because it leads to subsequent disputes on recognition and enforcement. The other piece of that is it is possible to have partial enforcement. So if one bit of your award is carved off as being outside of scope, that doesn't mean the whole award is necessarily doomed. The next ground is composition of the tribunal. So if the composition of the tribunal was not in accordance with the arbitration agreement, that's a ground for refusal of enforcement. This comes up, for example, if you've challenged an arbitrator during the course of the arbitration on grounds that the arbitration agreement, let's say, provided that the tribunal member had to be an expert in construction. You can have arguments over what constitutes an expert in construction, and you might have someone attempting to refuse enforcement on grounds that the arbitrator wasn't sufficiently expert in construction and hence wasn't properly qualified to be an arbitrator in the dispute. Very quickly, a court may postpone or refuse enforcement on grounds that the award has not yet become binding. It's permissive as opposed to mandatory. So if there's a set-aside challenge in the courts of the seat, enforcement in other jurisdictions may be postponed pending the results of that set-aside challenge, depending on the will of the courts where you're seeking enforcement. Those are all grounds that can be raised by a party. There are two additional grounds that can be raised by the court themselves. One is where the subject matter of the dispute was not arbitrable. And there are certain categories of disputes that in general are, and you have to look to local law on this question, but there are categories of disputes that are not arbitrable. So marriage and divorce would not be arbitrable in most jurisdictions. Tax disputes in many jurisdictions are not arbitrable. Certain types of intellectual property disputes, like patent registrations, are generally not arbitrable. So if you're in one of those categories, enforcement might be refused. And then the final kind of catch-all is the recognition or enforcement of the award would be contrary to the public policy of the country in which recognition or enforcement is sought. In most kind of modern arbitration-friendly jurisdictions, that is a very narrow category. In jurisdictions that have a tendency to be protectionist of local entities and dismissive of foreign parties seeking to enforce against those entities, that public policy exception can be abused in some circumstances, in some jurisdictions. I note the time, and so I will stop there. I'm happy to answer any questions that may come up.
Thank you very much, Brenda. That's terrific, and we're almost exactly to time. I'd just like to conclude by thanking all of our speakers, of course. Very grateful, and particularly grateful to the Bar Association, Jordana, and everyone else who's worked hard to ensure that this has run today with as many participants as we have. The last thing I want to say is just really to conclude is that there's really going to be three areas which are going to affect you in your day-to-day practice, which the Arbitration Act will hopefully leave as its legacy. The first one is when a client comes to you and asks you to advise them in the situation of a foreign party and a contract. Is this going to be suitable for arbitration? So that's the point at which you can say, is it the kind of dispute that could be arbitrated? What do we need to do? We need to look at inserting an arbitration clause. If we do that, you've chosen arbitration, you haven't chosen court, but there are good reasons to do that because you don't actually have an option because this is a foreign party, and if we got you a judgment in the Palauan courts, there's not too much we could do with it. The second area, again in summary, is that a client comes to you already with a dispute. There's a contract with an arbitration clause. How do you advise them then? Occasionally your client may say to you, I'd just like to go into the court now and start to litigate this. Well, your new act provides that you can't do that, that if a party wants to go to court but has an arbitration clause in it, then the court will need to stay those proceedings in any event. So you'll be advising them on not going to litigation but to going to arbitration. And of course, the third point, which Brenda has just been addressing, is that a party may come to you with an award, an arbitral award already, which they want to either enforce or resist in Palau, and you may be called upon to advise in that regard. So they're really the three key areas in which you may be called upon to advise. I just want to finally mention that you probably have a situation there now, as we did in Australia for many years, where your courts don't necessarily have arbitration rules now as to how you might go about enforcing an award. That's something that the ADB has assisted in other jurisdictions with as part of this reform. So if there is a demand for that, people should let us know. And finally, I just want to say again, thank you to those who assisted here from the ADB side in making this possible. We thank you very much for doing that. If there are any questions, I'll just leave this open for a minute or two. I've just got a few questions here and some thank yous. We've had some questions particularly about land law, because I know that land law, as in all the South Pacific jurisdictions, is probably the most controversial area. And you're trying to piece together how land law and international arbitration may work hand in hand. It's probably mostly going to come up at the enforcement stage. That is, if there are certain orders in relation to property. And ultimately, then that may be a question for the courts in Palau to determine whether or not that would offend public policy. So that's a very helpful question from that participant. Thank you very much. So I'll end proceedings now. Again, thank you to our speakers, thank you to our participants, and we look forward to visiting you in Palau as soon as we can. Thank you very much. Goodbye.